Good afternoon, everyone. I am Sarah Coombs from TBA Law. For those of you who do not know me, I am the family lawyer here at TBA Law, working primarily with other people to resolve their family law dispute issues. And these sessions with Sarah, we aim to answer your questions about family law as best we can, although it's always recommended that you do see a lawyer to better understand these and how they apply to your individual circumstances. But today we're talking about spousal maintenance. What is spousal maintenance? It is very much, or can be categorised, I guess, as financial support paid from one party at the end of a relationship to another. You might be more familiar with the American term alimony. It functions very much the same way. It is for someone's upkeep and welfare when they cannot afford to do so themselves. So it's often a periodic payment, but there are different ways it can be dealt with, and we'll talk about those shortly. The important thing to know about spousal maintenance is it can apply to relationships in which you are a de facto couple, meaning that you're not married, or you are a married couple, separated or divorced. So there are many different circumstances in which spousal maintenance can apply. And the main cause for starting spousal maintenance is you must establish that there is a need that needs to be met. So that without spousal maintenance, that person could not afford to live to the same standard as when they are getting paid that. So that's the first element of spousal maintenance. The second is the capacity to pay. So it can't just be that you need a higher standard of living and you seek money from another party to help cover that. It's the other party must have the capacity to pay that spousal maintenance as well, which is where things can often become a little bit tricky. But really it's when one party cannot meet their expenses from their income and the other party has the capacity to help them meet those expenses. There are many different factors that can come into play when assessing spousal maintenance. It is not something we do on every single family law matter. In fact, it's fairly uncommon at the moment to have a periodic payment of spousal maintenance. Having said that, it doesn't mean it is not done. The first is the age and the health of the parties. So if parties are in good health, if party is too unwell, particularly too unwell to work, or retired and another party is still working, there may be a spousal maintenance claim as a result of that. The next is income, property and financial resources. If both parties are on a similar wage, living in a similar standard of income, there's unlikely to be able to be made a spousal maintenance claim. Similarly, in circumstances where both parties have a huge amount of assets, more than they need to survive, it's very unlikely that spousal maintenance will need to be done. However, if one party owns 10 properties each worth $10 million and the other owns nothing, there's likely to be some sort of spousal maintenance claim. The ability to work is a huge factor because obviously that plays a huge role in your income earning ability. The ability to work is not just necessarily the physical or mental ability to work, it's also the terms of time capacity. So it may be that you have children or the full-time carer for an adult disabled child or something like that. That may cause a spousal maintenance claim to arise. The suitable standard of living. This is another one. It is a little bit complex in that standard of living is very different from party to party. Parties who have an asset pool of $100 million have a very different standard of living to parties who have an asset pool of $100,000. Therefore, there may be some sort of claim to keep someone in the same standard of living that they had prior to the marriage. Although that's not necessarily always true, but definitely a key factor. If the marriage has affected a party's ability to earn income, this is a huge one and is particularly relevant in circumstances where one party has taken time off to help raise children. So for example, someone was in a high paying job, they took time away from work to raise children and they're unable to get back into that job market because their skills have been superseded in that time. Another good example of that is when a party relocates to be with their spouse and then subsequently separates. Particularly relevant to defence families or people who come to live in Australia from overseas to be with their spouse. You might not have the same ability. You might work in a very niche market in Melbourne, be required to relocate to be with your spouse to remote Northern Territory, and you can no longer work in your role. You can no longer make that income. That may cause a spousal maintenance issue to arise. And the final major factor is children. So if you have the sole care of the children, it's expected that you might have some sort of claim for spousal maintenance on the basis that you are caring for them. It is separate to child support, which is done through the Child Support Authority, and they are not dependent on one another, although it does need to be declared. In terms of spousal maintenance, it's really important to acknowledge that, like I said, often it is done not necessarily in periodic payments. So it is possible to do, you know, a monthly payment of $100, $200, whatever. It's also possible to receive a greater lump sum of a party's asset pool in lieu of spousal maintenance. So instead of having a 50-50 split of assets and a payment of $1,000 for the next 10 years, every week for the next 10 years or something like that, it may be the person gets 60% of the asset pool, the other party gets 40% of the asset pool, and they therefore sacrifice their claim for spousal maintenance. Not always the case, but it's something we do very often. We often don't recommend people enter into spousal maintenance agreements sometimes, because if your income earning capacity changes, it could have a detrimental effect on the amount you're paying and your own standard of living, in which case you might need to apply to the court to have that order varied or revoked. Another very important thing to note about spousal maintenance is that a new relationship can affect your claim for spousal maintenance or end it completely, particularly if you're married, and if you are already in a new de facto relationship, it is possible that de facto relationship will be taken into consideration when a court determines your need for spousal maintenance. In terms of timelines for spousal maintenance claims, they are the exact same as property or making a financial claim against the former spouse. So 12 months after the date of divorce or 2 years from the end of a de facto relationship. So it's very important to be aware of those two timelines to make sure you don't miss out in case it is needed. And finally, what is the process? Spousal maintenance forms part of the family law process for splitting financial assets and liabilities. So it's possible to negotiate these outcomes, to mediate these outcomes, or apply to the court. I don't want to go too much into process because it is a very tailored thing, but what you can do is book in with one of our solicitors and we can discuss spousal maintenance and how it applies to your situation and what the best path for that is. I hope that's given you a bit of better background on what spousal maintenance is, and if you have any questions you can book in with a solicitor, but like I said, it's really important you get your own tailored legal advice on spousal maintenance because it is something that is very much tailored to your circumstances. Thank you everyone.